Friends, I just pressed the let's go live button, and so we've got to wait for the stream to fire up all across the fruited plain of the internet before we can go ahead and get started. Got to make sure those tubes are connected. Of course, it is Thanksgiving Eve, and sometimes, you might get a little stuffing in the tubes over there on the Thanksgiving table, but it looks like they are alive and well. That's tremendous news. And that means we can go ahead and get started. So let's do it, shall we? Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live, the show that spotlights misconduct involving police, prosecutors, and politicians. My name is Robert Gouveia. I'm a criminal defense attorney, and today we're talking about Donald Trump's and his ballot removal case in Colorado, his appeal. Now, this is going into Colorado because we covered this trial some time ago. We remember Judge Wallace was the judge who heard the election challenge saying that the petitioner saying that Trump violated the insurrection clause of the 14th Amendment and that he needed to be removed from the primary ballot before the voting starts there in Colorado. Well, turns out Trump won. You remember this judge, Judge Wallace right here. Trump won on the main issue, which is really the removal portion of this, but he's not done yet. The people who want him removed have submitted an appeal to the Colorado Supreme Court. We're going to take a look at that. And Trump also submitted an appeal. So we've got two different competing petitions that are now going up to the next layer court in Colorado. Of course, Trump is saying, we're very grateful that the judge came to her senses and realized that the 14th Amendment doesn't apply to the president. But we're concerned that she did say that there was an insurrection that was committed and that he was behind it. And of course, the Colorado Removal-Petitioners, they are arguing that Trump did in fact commit the insurrection as the judge found, but also that the 14th Amendment does apply to him and so he should be therefore removed. And so we'll take a look at both of those petitions that are in the Supreme Court there in Colorado. And Colorado, of course, is accepting jurisdiction on this and scheduling some further briefing. And we'll take a look at what the calendar has in store for us there out of the SCOTUS docket. So that is coming up. Then we're going to hear what is the take from Trump's lawyers. This is one of Trump's lawyers who was there at the trial in Colorado when it was all happening. He was arguing some of the points there. And he gives us a little bit of a take on what's happening from his perspective, saying that this appeal is happening and we are grateful with the outcome and so on. So we'll get into all of that in our first segment. Then in our second segment, we're going to turn our attention over to the January 6 cases because we've got Judge Chutkan and a new order from her courtroom. And we're going to find that Judge Chutkan, in fact, denied Donald Trump's motion to strike the inflammatory language out of the indictment. We've covered this some time here. Jack Smith submitted an indictment that was filled with all sorts of colorful language, like Trump's an insurrectionist and so on and so forth, and didn't charge him with things like, insurrection. And so Jack Smith opposed this motion. Donald Trump filed his reply, and we're going to see what ultimately happened with the filing when we get to that segment. Then we're going to get some reaction from Rachel Maddow. Clavicle Girl is going to make an appearance. We've got Dan Goldman, who made the statement that we need to eliminate Trump. And his statement was a little concerning. It caught a lot of attention in the media. And then people were arguing, why is he allowed to say these things and not be indicted by the feds when Donald Trump, he says anything like fight and it turns into a giant catastrophe. He came out and apologized and says, oops, I'm sorry about that. I used the wrong word here. And we'll also see some of the language from the former senator, Claire McCaskill, who's basically arguing that Trump is worse than even Adolf. Now we'll go through all that. Then we have some other updates from Congress. The Judiciary Committee, Jim Jordan, sent in a subpoena over to Lesley Wolf. You know Lesley Wolf. We've talked a lot about her here when we've talked about the Biden crime family. And she is a major Obama donor, a major Democrat donor. And she was the person who we were very suspicious of because the whistleblower said that she, a DOJ prosecutor, was somebody who was tipping off the Biden crime family when they were about to go do a search warrant on his storage facility. They were tipped off and apparently exited the storage facility. And so the things that they were supposed to go find were never found. Isn't that convenient? And so we'll see what she does about this, but we'll learn a little bit more about her because I found a good article that details some of the donations, some of the money that she donated to the Democrats and the Democrat causes. And of course, she's covering up, in my opinion, for the Biden crime family. But the subpoena went out from the Judiciary Committee, and then we're going to hear what James Comer says about an update on the Biden crime family investigations and what is happening from his perspective over on the Oversight Committee. And you can see James Comer looks a little bit rough there, looks a little tired. You know, he's probably tired of signing all these subpoenas. I mean, digging into the Biden crime family is a lot of work, my friends. And so hopefully he gets some rest over this break. And so we've got some good stuff to get to today, my friends. I'm glad that you are here and with us, and grateful that you are here with us on our Thanksgiving Eve show. This morning, we had a good members only stream, which was a lot of fun. We talked about this Arizona case where We the People Alliance sued Runbeck essentially to get some documents that Runbeck allegedly had in their possession, because Runbeck was an entity that did a lot of the work here during the 2022 elections with some ballot stuff, and they wanted access to some video files that Runbeck supposedly had in their possession. Well, filed a lawsuit, judge dismissed it all, said, sorry, they're not a public company, they're a private company, and so they're not susceptible to the Arizona public records law. And so if you have any questions about what they did, you're not really entitled to those. Sorry, get bent, essentially. And so we talked about that this morning on our members only stream, and so that segment will be coming out a little bit later, but we're grateful to our members as well who join us. Of course, if you'd like to join us for those morning streams, you can do that over at watchingthewatchers.locals.com. And we'd love to see you over there. We do member streams in the morning. We do some extra stuff for members on Saturdays and things. It's kind of holiday seasons, you know, so things are a little bit wonky right now. But we are going to be posting some extra stuff over the holiday break. I'm going to be going up north a bit. And so we should have some fun stuff and some updates as the stories continue to drop over the holidays. But come and check us out, watchingthewatchers.locals.com. We do streams in the morning for members. We do Saturday shows, and we have a lot of fun. We also have our website, robertgovea.com, which I'll send you to if you want to sign up for our daily newsletter. So all the videos, all the segments that we talk about here are translated into reports, published on our website, and then also we attach the PDFs there. So if you want to go through the red lines, any of the documents we're about to go through today, you'll find those at robertgovea.com. Download the PDFs, share the reports with your friends, sign up for the daily newsletter that's there so that all of this stuff just gets delivered to your inbox. And then we always appreciate you forwarding those emails to people who you think need to be in the know, because there are a lot of them who need to be in the know. All right, and so my friends, without any further ado, let's get into it on this lovely Wednesday. It's not Friday. It kind of feels like a Friday, but it's not. It's Wednesday, which is good because we have Thanksgiving tomorrow, Thanksgiving Thursday, and we have to enjoy it. Okay, so getting right to it. Donald Trump appeals the Colorado Ballot Removal ruling, but only a portion of it because he pretty much won it. They wanted to get him off the ballots. The judge says no, the 14th Amendment insurrection clause doesn't apply to the presidency. But there was that little problem that the judge had in her ruling, saying that Trump is in fact an insurrectionist, saying that he kind of led an insurrection. There was in fact an insurrection, and she spent a lot of time talking about how he's a criminal, essentially somebody who was undermining American democracy and so on and so forth. And so obviously Trump doesn't want that precedent to stand. And so he has submitted a notice of an appeal in Colorado to the next higher court. And we're going to go through that in detail, but he's not alone. The people who wanted him removed in the first place, we're calling them the Colorado Removal-Petitioners, the people who don't even want him on the ballot because they're like, he's so dangerous to a democracy. We can't let Americans vote for him because if they do, maybe they'll put an insurrectionist in the White House. What? All right. Whatever that logic is. They say we can't even give people the choice. So we're going to remove him. And they also submitted an appeal saying that, no, he is an insurrectionist. You got that part right, Judge. But the part you got wrong was that the 14th Amendment doesn't apply to the presidency, to the office of the presidency. Now, the Supreme Court there in Colorado has accepted this. We'll take a look at what the calendar says here on what the briefing schedule is as these appeals move forward, because Trump's not done yet. And then we'll hear what one of Trump's attorneys who actually argued the case in Colorado said, because he showed up on CNN and got into it a little bit with Caitlin Collins. And so we'll start right out by seeing what the petitioners said in the first place, because we know that they are unhappy with the ruling. They obviously want this to go the other way. And this is what they have in their filing. Now, again, this is the Supreme Court in the state of Colorado, which is where they're submitting this. And this is just the opening salvo. When we get the appeal process underway, there's generally two parts. One is you kind of submit a notice that you're appealing. Hey, this is what's coming up. This is the issue, and so on. And then you'll submit a more, bigger brief once the court grants you permission to actually be there. Then you say, okay, now we're going to really beef up our original filing. So one's like a notice and then one's like the actual brief, and that's really where the meat is. So here we see these are the petitioners and the respondents. Of course, we've got the interveners, and this is Trump and the Colorado Republicans. And we're now at the Supreme Court in Colorado, and they write the following. They say, all right, petitioners, meaning the removal people, they file this notice. We're upset. We're appealing the final decision of Judge Wallace in Denver. Now, this is an expedited matter and requires expedited briefing, man. We've got an election coming up any minute. We got pending deadlines for ballot certification. They want to keep Trump off the primary vote. And they've got potential appeals of this court's decision. So the Colorado Secretary of State must have all appeals, including any potential appeals to the United States Supreme Court, right? We can still go up above Colorado. Resolved. We got to get all this stuff done, they say, before January 5th, when ballots must be certified for Colorado's March 5th, 2024 presidential primary election. And that's right around Super Tuesday. I think Trump's trial in the J6 case, which is, don't you just love this timing? It's wild. So Trump's January 6th trial is starting, I believe it's March 4th. So one day before the presidential primary election. So they're trying to remove him in Colorado on the basis of a so-called insurrection. And the day before Colorado people go in to vote, he also gets prosecuted, and trial starts on March 4th in Washington, D.C. for an insurrection trial. So everywhere you turn, it's insurrection. Now, to aid the court in expediting this matter, says the removal team, a full brief on the one issue that petitioners seek to appeal is concurrently filed with this notice. And consequently, this notice does not endeavor to provide a full narrative description that's usually provided under the rules, right? If this is accepted and we can move forward, then we'll fill this out. They say here, we know that Trump, oh man, he filed his own notice of appeal, so he's upset too. He doesn't like this ruling either. And the court should consolidate these under the rules. However, we, the removal people, we request that all matters be expedited due to the impending deadlines. Like, they want to go fast because if the ballot removal deadline comes and goes, then we'll see that this becomes moot. There's nothing else to really talk about if the ballots have already been printed and Trump's name is on there. So they're in a hurry. Okay, Trump is not in a hurry. They say here, expedited, we got deadlines, we got further appeal, like if you deny us, we're going up to the SCOTUS. And we've also got difficulties surrounding the upcoming holidays. And all this is also true. Like this actually is a thing, okay? It's hard to get stuff scheduled. There's judicial conferences and stuff. It's always, not only the holidays, but it's like suddenly everybody's got a judicial conference. You know what I'm saying? Can we schedule this? Sorry, the judge is out. Why? Conference. Oh, really? For 2 weeks? In December? That's nice. 2-week conference. Got it. All right. So, it's just everybody suddenly kind of goes missing and things slow down a little bit just by happenstance. Very weird. Now, to that end, petitioner appellants, they request any additional briefings be ordered, meaning the removal people. We want any additional briefings here also on an expedited timeline. So we know Trump is appealing, and he's probably going to want long deadlines, but don't let him have them, okay? Give it to us. Make sure that we can go fast here. We also believe that expanding the word counts beyond those in the rule would be in conflict with the expedited nature of this case and necessary to resolve the matter as quickly as possible. So we're going to read Trump's basically simultaneous petition, and we're going to see what he says. And he's going to say, oh, no. Can we have more words, please? Can we have more time, please? Judge, we don't want to interfere with your vacation schedule, so you should definitely go enjoy that. And we'll just deal with this like in 2027. How about that? So final, they say here, petitioners, the removal, they seek review of the final order issued by Judge Wallace, who I have to admit surprised me. I was wrong on that. I thought that she was going to remove him because it's just the most interesting way that this was going to go, but she didn't. Surprisingly, even she's not, willing to push the psycho button like the rest of them, and entered on November 17th, which has been attached to this application. Now, the lower court's order, final order, resolved all pending issues before it and was final, and so no post-trial relief has been sought. Now, they say this court has direct jurisdiction over this case, saying that petitioner appellants request review of the following. This is the issue that is going to be on appeal. And again, we're not going to do a whole trial again, right? We're not redoing all of this. We're just really certifying this question and then asking whether this was determined to be accurate under the ruling of the judge. Question: did the district court, Judge Wallace, did she commit reversible error in ruling, complex question, that Section 3 of the 14th Amendment, which disqualifies people who engaged in insurrection, which she found, against the Constitution after taking an oath to support the Constitution, does not apply to presidents who engage in insurrection or to insurrectionists wanting to be president? Now, we're going to put a pin in this one, right? We're going to come on back to this one here in a minute because we're going to see how Trump frames his question, right? So you see how this kind of changes a little bit. It does not apply to presidents who engage in insurrection because they're presuming, right, Trump was found to be an insurrectionist under the judge, but it doesn't apply. Or let's get rid of the presidency stuff, really, and broaden that to insurrectionists wanting to be president, right? Kind of that's a question that we weren't really asking there, but you could extrapolate from that. Like the question is not, did somebody who, let's say, Jacob Chansley, for example, who I think is running for the House in Arizona or filed a notice of intent to do that. Shout out to Jacob Chansley there. The QAnon shaman, right? The so-called insurrectionist who wrecked America with his hat and his horns that was going to seize control of the whole country or something, idiots. Now, they are asking the question, what if he is successful in his run for office and then he suddenly turns around and wants to become president? Can he run for president? And that would be acceptable? Well, nobody really is asking that right now because the question is, first of all, did Trump commit an insurrection? She says yes, but he was a president when it all happened. And so does that apply to him and his conduct as the president? Which is a little bit narrower of a question. So we'll see what Trump says in response. So they say, all right, transcripts of the hearing from the dates October 20th through November 3rd, which is a lot of the Colorado trial, which we covered here, will be necessary for this court's review. And if you missed the Colorado stuff, by the way, and want to get caught up, we have it broken down into a playlist on YouTube, so you can check that out. We're taken contemporaneously with the proceedings, and all of the transcripts have been provided. They tell us that all these people have certified it. Dillon Law Group is in the house. And receiving some of these filings, shout out to Harmeet Dillon and others. So these are people who have been certified as receiving notice of our appeal. So they're aware of it. Signed by Jason Murray for this law firm who's representing the removal individuals. Okay, so that is their appeal. Now, simultaneously to this, Trump also appeals his filing, and this is what this one looks like out of the Colorado Supreme Court. They write the following. Dear Colorado Supreme Court, President Trump also simultaneously seeks review and adjudication of Judge Wallace's final order, saying a district court decision may be reviewed and finally adjudicated by the Supreme Court of this state if either party makes an application to the Supreme Court within 3 days after the district court proceedings are terminated. And of course, they are here. They say President Trump is a party in the district court proceeding. The verified petition originally named him as a respondent in the second claim for relief, and following voluntary dismissal of that claim in the district court, granted Trump's motion to intervene in the first claim for relief. So there was already a battle. There was a lawsuit, basically the petition removal people sued the government, and then Trump had to intervene. They were trying to, if Trump didn't intervene, they, who knows what they would have done. They would have just, maybe not even had a trial. They would have just agreed to throw him off the ballot. Who knows? Who knows, in other words, what Colorado would have done. But Colorado Republicans joined in. Trump joins in as an intervener. So the district court finally terminated the proceeding after we got the final order, which really split the baby in half. Is that the phrase? I don't know. So I don't maybe that's not. But, both sides kind of lose. Like, Trump, you're an insurrectionist for sure. Like, you committed it, but we're not going to remove you from the ballot because it doesn't apply to you. Kind of like a technical thing. Then the other side's like, see, we told you he's clearly an insurrectionist, but we can't remove him because it's just technical. But maybe we can appeal it. Maybe that technicality will be reversed. So Trump says procedurally, the court confronts this matter for the second time. President Trump filed several motions to dismiss in the lower court, all of which were denied. And then President Trump filed a petition for relief seeking the review of the district court's orders. So Trump is basically saying, we've already been here. And this court denied that petition. Like, we could have already addressed this. Hello? Stating that it sought to maximize efficiency by considering all of the issues on appeal. So they said, don't appeal now, wait till the trial's over and then appeal all your stuff. And they said, all right, in that first appeal, before the trial started, they said this court explicitly reserved issuing an opinion on the merits of our relief. They said, we're rejecting you now. Trial is going forward. Bring your issues up together and we'll deal with it then. Following adjudication of several other issues and a 5-day hearing in Colorado, the district court and Judge Wallace issued its final order and denied the petitioners the relief they sought, meaning the removal team loses. They ordered the Secretary of Colorado to place President Trump on the ballot. Oh, and that must have hurt for them. But the district court nonetheless made legal and factual findings wholly unsupported in the law. So Trump, even though we win, we're unhappy with the other finding, right? That insurrection nonsense is nonsense, and we're going to be challenging that. And these errors demand review, especially if the petitioners in this matter also seek review of the sole dispositive issue upon which President Trump prevailed. Now, he's talking about the removal team. He says the removal team in the matters below have confirmed that they are also going to seek review of the adjudication of the final order. And so they just are, smashing these two things together. They're filing. And they're saying, are you filing? They're like, yeah, we're filing. What about you? You filing? Yeah, we're filing too. Well, when are you filing? Whenever we feel like it. How about you? Well, whenever we feel like it. And you're like, oh, well, how about, And so now they're all pointing to each other. So they say President Trump seeks review to ensure that if this court takes up this case on appeal, if you're going to take their petition up, that you take our petition up. And you consider the full scope of the constitutional, the interpretive, and the evidentiary issues. To be sure, the district court, Wallace, grounded its ruling on a correct textual analysis of the U.S. Constitution in Section 3. This was perfect, Judge. Nice job. When it held that Section 3 of the 14th Amendment does not apply to the president. But even though she was pretty good on that issue, nicely done, Judge Wallace. Really fooled us on that one. You nonetheless committed multiple grave jurisdictional and legal errors. But not on that first part, though. That first part was like perfect. Well done. But now then you screwed it up. And those include adjudicating. And by the way, I know I'm kind of being jokey here, but the other side's saying the opposite, right? They're saying, oh, no, your insurrection clause, that was like perfect. Absolutely outstanding. Definitely an insurrectionist. But you're kind of dumb when it comes to the Constitution. So they say here, Wallace, you committed multiple grave jurisdictional and legal errors. Those include adjudicating constitutional issues in a proceeding under Section 113 and then creating new, unprecedented, and unsupported legal standards in applying Section 3. You just kind of made stuff up. Importantly, Trump's defense says this matter on appeal encompasses multiple issues of first impressions that affect Coloradans and all Americans' ability to select a president, particularly if Trump is barred from the ballot, it would be kind of insane, honestly, which is, I think, is why the judge is like, I'm not going to do this. Like, I know I'm going to get in trouble at my cocktail parties around the holidays. All the people are like, they walk up to everybody else in the circle and they're like, would you guys like more hors d'oeuvres? And they look over at Judge Wallace, like, no hors d'oeuvres for you. She's like, well, I'd like one of those pieces of cheese. No cheese for you. So a full review requires analysis of the errors made by the court below. In fact, we have identified 11 issues for review. Trump's lawyers recognize that this is an unusually large number of issues, each of which itself is worthy to stand as a single issue on appeal. So this judge is, man, she's pretty bad. 11 problems, and we know that like identifying 11 problems is kind of a lot, but we got to bring them up. But if this court chooses, if you choose to exercise discretionary review of Judge Wallace's final order, and if you accept this appeal from these petitioners, well, if you want to open this can of worms, guess what's going to happen? A comprehensive review of the district court's errors is necessary. We're going to really dig into this. Pandora's box is going to be opened. Now, those errors affect weighty public policy considerations and serve as faulty interpretation of important constitutional issues. And as the court earlier noted, considering all issues in one proceeding, as you said earlier when we were here before this all happened, will maximize efficiency in the event this matter is appealed. So, you said you want us to bundle it all up. Well, guess what? We're here. We've got 11 issues to bundle up. Now, because of the complexity and the number of issues that are involved in this case, as well as the possibility of further review, President Trump asks this court to set a briefing schedule and also to increase the allowable word limit to 19,000 words. Oh, yeah. We love those extra word limits. Can we have more pages, please? Because we're going to need more time to fill those pages up, And we need those 19,000 words for both opening and answer briefs and 8,500 words for the reply brief. This will allow for full discussion of the issues before this court. Now, I don't know what the regular, limits are in Colorado, whatever the word limits are, but hopefully it's a lot bigger because we know they don't want it. The petitioner removal team, they're like, can we just keep it to like 2 pages, please? We have to go very fast and get him off now. Now! So they say this is the final order that we want to appeal. Court's final order issued back in November. This case have a couple questions. Are you requesting any additional time? Nope, not right now. Here are the possible issues. Now, again, I want to point a pin in how they framed it versus how Trump's team frames it. They say the district court held a 5-day hearing beginning October 30th. But under Section 113, it prohibited discovery and allowed only 5 weeks to prepare a defense. So we had no defense at all, meaning these petitioner people have obviously been preparing their case for probably years. Like, I would estimate if I were plotting something like this, I would try to pick the best forum, try to find the best judge, come up with a rock solid case, get the best experts, make sure your PowerPoints are all nice and beautiful, right? Have everything lined up, file it so that you can exploit the deadlines and really rush the defense in their response. Like, Your Honor, like we filed it. So, well, you could have filed it a long time ago. Well, it wasn't ready yet. And, so you just time it and then the judge favors them and the defense is on their heels. This is the same pattern that we saw with prior election stuff back in 2020. We're up against deadlines all the time. And the defense or the petitioners, right? Basically the courts will orchestrate it to hold it against Trump. If Trump files something, they say, sorry, you're out of time. You don't have time for discovery. If they file something and Trump responds, they say, sorry, don't have enough time. You can't have discovery. Everywhere you go, right? Trump is kind of on his heels because they are the party doing the attacking. Now, this court's rulings, they say, directly prohibit litigation of constitutional claims in a Section 113 proceeding. In other words, the judge heard claims that she should not have heard because the district court is limited to ordering compliance with the election code. That's it. And because Section 113 procedures are incompatible with adjudication of constitutional issues. Love that. That is so good. And it feels absolutely true, right? Why can Judge Wallace expand the scope of just election litigation to adjudicate an entirely new novel constitutional issue that nobody's ever heard about. And we saw what this trial proceeding looked like in the Kari Lake trial. We covered that here, live, a lot of it. And we saw that there are different rules, right? It's not even really a civil trial. It's not a criminal trial. The standards are much lower. The burdens are much higher for the challenging non-moving party. And the timelines are a lot more compressed. So it's a lot less of a procedural protection than you would get in other types of litigation in this country. So why then, with those minimal protections, can the judge just essentially say, if she didn't do it, she could have, he can't be on the ballot? What kind of procedures are those? Now, they asked this question: should the district court's opinion be vacated for lack of jurisdiction? In other words, this whole thing should just go away. Yes, she ordered that he should be on the ballot, but he should already be on the ballot. And this whole dang thing should just go away. Should the opinion be vacated? They also say the district court ruled, Judge Wallace, that Section 3 did not apply to the presidency because he's not an officer of the United States. But the district court nonetheless applied Section 3 to Trump, finding that because he, quote, engaged in an insurrection, that she made the finding, right? She said, no, he did engage in an insurrection. Okay, but you just said the 14th Amendment doesn't apply to him. So how could you say, why would you even do the analysis on engaging in an insurrection if you say it doesn't apply to him? It's logically inconsistent. And they're pointing that out. Now, should these findings be vacated because the district court self-admittedly lacked the jurisdiction to apply this to President Trump? Great question. We'd love to know what the court says about that. Another question: did the district court correctly, here's how they frame it. The district court correctly held that Colorado law, nor any other provision of the election code, grants the secretary authority to investigate or remove a presidential candidate under Section 3. But the court nonetheless ruled that it could adjudicate candidate eligibility under Section 3 and issue orders requiring compliance with the 14th Amendment. Can a district court, in this case in Colorado, under Colorado law, determine candidate qualifications under the rules, even when the election code says that there is no authority to order that relief? Right? They brought a claim. In other words, the people who tried to remove him brought a claim under the law. And then the judge just said, you know what? Maybe he is an insurrectionist. And we're saying, does the law say that they can bring a claim to remove an insurrectionist from the ballot? And they said, no. And the judge said, I can do that. Now they're saying, okay, well, let's find out. Now, Congress has not authorized, they're pointing out, the state courts to enforce Section 3, and the U.S. Constitution specifically grants Congress the authority to implement the provisions of the 14th Amendment. But the district court held a hearing and, for whatever reason, made findings under Section 3. Now, may a state district court adjudicate Section 3 disqualification without Congress authorizing the statute to do that? Another good question. Now, as a reminder, right, they only had the one question over here on their end, where they were just saying, did she screw up on that second portion? Did the district court commit reversible error by saying that the 14th Amendment doesn't apply to Trump? So we continue. He says, does presidential disqualification under the Constitution present a political question non-justiciable in a state court, as multiple state courts have held? In other words, should the people be able to vote on it? Okay, you can't file lawsuits against the government because of political questions. Okay, so sometimes people will ask here, Rob, can we just sue the government to challenge them for violating our rights? Can we just file a lawsuit against them for violating this right? It's like, I wish, man, I wish. But no, you can't, right? It's a political question. The courts have just said, nah, if we allowed that as a matter of policy, everybody would be suing them for everything. So they call it a political question. If you're unhappy with some policy, you got to really go vote for candidates who will work against that policy. So here, is this disqualification something that some district court judge can just decide, or is this a bigger issue? For the first time ever, they say the district court found that the phrase engaged in, as used in Section 3, includes the word incited. Never learned that in our law before. Nobody's ever determined that. She did. Was the district court correct to define engaged in so broadly? The district court, Judge Wallace, also ruled that President Trump and his political speech, quote, incited violence, even though the words he used never advocated violence at all. Instead, Wallace found that Trump and his supposed intent and the effect of his words, right? She sort of was reading his mind, and the effect that sufficed to render his speech unprotected, incitement. Now, did Wallace err in its application of the First Amendment standards to Trump's speech? Did she do good analysis there? Did Trump's speech actually mean that he broke the standard that protects free speech, the Brandenburg standard? This is actual incitement? Good question. Now, the district court relied upon President Trump alleged his delay in deploying the National Guard. She said Trump was just delaying, dilly-dallying, like Liz Cheney said. Now, she said that that was a basis to determine that Trump recklessly endangered people and so-called engaged in the insurrection. The Supreme Court has repeatedly, they're telling the Court of Appeals, or the Supreme Court in Colorado, hey, reminder, SCOTUS, they has repeatedly made clear that courts may not second guess a president's discretionary decision-making in this area. Obvious. And we've been making this point for years now, ever since Liz Cheney said, he should have driven over there and beaten him with a broom or something. Whatever she said Trump should have done, it's not her decision. She can't substitute her discretion for his because she's not the president and never will be. Did the district court's decision improperly invade the province of the federal executive branch? How dare they second guess him? Now, the district court defined insurrection through Judge Wallace as 1, public use of force or threat of force, 2, by a group of people, 3, to hinder or prevent execution of the Constitution of the United States. They say, well, that's curious. Where did that come from? Because we have this thing called precedent in the law. We're supposed to follow it, meaning you don't just make stuff up in your courtroom. But they make the point, this definition, however, is new, and it's without precedent. Did the district court adopt the proper definition of, quote, insurrection in holding that the events of J6 constituted an insurrection, right? And this is where we were getting concerned about this. It's like, is she defining things that are going to make their way up and make their way into the law? Are they going to try to use this stuff and this definition that a federal court found, a state court found he committed insurrection as some sort of evidence in his criminal cases? We'll see. Now, when particularly important individual interests, such as constitutional rights, are at issue, they say the proper standard of proof requires more than just a preponderance of the evidence. Okay, we have constitutional protections, like if they're going to dump all over your right to remain silent, right, you go through the Miranda process. It's important. We have constitutional rights for a reason. Not supposed to just censor people and ban them from social media platforms and have the FBI twisting arms to do it. And you're not supposed to just remove people from the ballot because we have a constitutional right as citizens of the state to vote for the people that we want to. And there are many people who want to vote for Trump. But the district court really is not applying to any standard, right? In a regular civil trial, not an election case, whatever this was, you have preponderance of the evidence. If it's more likely than not, the evidence tends to show it's more likely than not that the claim is met, then they are sufficient. We raise that dramatically in a criminal case because your constitutional rights are absolutely being challenged there, including your freedom to walk around society. So we raise the standard of proof to beyond a reasonable doubt, which you've heard about, a lot higher, meaning if there's any doubt based in reason about a person's innocence or the guilt, the evidence presented, then they are not guilty. Very high standard. But what the judge did in this case is just well, I don't know, it's an election. Tell us whatever you want to. The district court rejected this standard, preponderance of the evidence. More than that, reasoning that liberty interests at stake do not even require a higher standard of proof. No. Does potential disqualification, Supreme Court, does it, under Section 3, to hold federal or state officials, does it implicate important liberty interests or not? Like, does our right to vote for somebody on a ballot that we want to vote for, does that matter? Does that require due process? Does it require a burden of proof greater than preponderance of the evidence? Like, or can a judge just like wake up one morning and just, "Rah! By judicial decree, I find insurrection"? Do we have any safeguards or no? Let us know. Even before the J6 committee began its work, says Trump's team, every committee member previously determined, every one of them, Cheney, Kinzinger, all of them, through public announcements and an impeachment vote, they stated the supposedly, quote, obvious fact that President Trump, quote, incited an insurrection, right? It was already done. It was already concluded. The committee contained no members who disagreed, allowed no minority staff, and hired a television producer to package the committee's conclusions for maximum political impact. Now, did this bias highly unusual procedures with no adversarial even questioning, and this structure, and the report's extensive use of what they say is multi-level hearsay, does that render the report inadmissible to serve as the basis for Judge Wallace's determination that Trump engaged in an insurrection? Like, in other words, is that evidence terrible? We know the answer to these questions. We'll have to see what the Supreme Court says. They say transcripts are necessary. You can review all of these things. These are the people who are petitioning. We know their names. And they tell us Trump is intervening. Here are the attachments, a final order, a $223 filing fee, and copies have been delivered. Over to the Honorable Sarah Wallace, who made a very good finding on the 14th Amendment issue. Not so good on the insurrection issue, but this is signed off on by Scott Gessler and Jeffrey Blue, two attorneys for Donald J. Trump. Now, this is all going to be landing in the Colorado Supreme Court, and they, of course, are accepting this and giving us some scheduling. We're going to hear from Trump's attorney on the Colorado case in a minute. But you see, this is what the order of the court looks like. They say, all right, we got everything. Upon consideration of Trump's application for review and the petitioner's application for review, here is what we are ordering. We accept the cross applications for review. Now, given that we filed our opening briefs, they say petitioners, they filed their opening brief. They already did file his opening brief, so that has already dropped. Trump shall file his opening answer by November 27th. Then the removal team shall file their reply by December 1st. Trump's reply December 4th. And Trump doesn't get his way. The opening answer brief and the answer reply, 9,500 words in the opening answer brief and 5,700 words in the reply. Now, we've got a couple, amicus briefs are being granted. The Constitutional Accountability Center and constitutional law professor Mark A. Graber wants to file his brief, and so they've got some deadlines on that. Oral arguments are going to be scheduled December 6th, so mark your calendars and be sure you are subscribed, my friends, because we will be covering what happens here. Oral arguments, 1 hour each side. Counsel needs to check in. If you file written briefs, do so accordingly. Amicus filings will not be part of oral arguments, and the court will not extend the length of oral arguments to accommodate the amicus filing. So that is what it looks like. And of course, we're going to be here to cover all of that. We're going to see who is there arguing on behalf of the Trump defense. But this is an exchange between one of Trump's lawyers who was there arguing the hearing in Colorado and this woman from CNN. Let's listen to what it sounded like as she was asking him about the next steps. Of course, Trump is victorious on the removal question, but lost the insurrection question. And where does it go from here? This is Scott Gessler, who is one of the Trump attorneys.
The fact that she does go into such detail and is now the first judge to ever say that Donald Trump engaged in an insurrection, do you still really view this as a win here?
Yeah, he'll be on the ballot.
You know, we can't stop the judge from saying things like that and still ruling in our favor. But I will tell you, she also said that the First Amendment protections don't apply to President Trump the way they do to everyone else. And we think that's flat wrong. So there are a lot of problems with that analysis. Maybe that will wind up contesting it, maybe not, depending on how the appeal comes out. But at the end of the day, she ruled for us, and properly so. And this, is her opinion on what happened. But it has no legal authority at all because of her ruling.
But I guess some people would read this and see where she says that he acted with specific intent to incite political violence, directed at the Capitol, that he not only knew about the potential for violence, but that he actively promoted it and incited it on January 6, 2021. And they'll say, okay, yes, he is staying on the ballot, but the judge also is tying him to all of this activity, saying that he was responsible for what happened that day, and ask how this is a victory for the Trump team.
Look, part of the problem with that analysis is that what she did is she took the January 6th report, which was a wholly one-sided approach used to attack President Trump directly and politically. And she imported that whole thing into the case itself. She viewed that as reliable, which is, I think most reasonable people would view that as absurd. And so she relied upon that to make some of those
decisions. There are people who would not agree with that.
The foundation
right,
of that
Scott?
is rotten. I'm sorry?
There are people, yes, there are some people who do not like the January 6th report. There are a lot of people who believe its findings. I mean,
Great question,
I saw you
Caitlin.
making this argument
Liz.
in court, saying that you didn't believe that should be something that, the other side was basing their argument on here. But is there anything, is there anything, I guess, in the facts that she's laying out here and the statements that she's laying out here that you dispute about Trump's behavior on that day?
Absolutely. He did not act with intent or specific intent at all. We thought the evidence was very clear that he made efforts to ensure he authorized the National Guard to make sure that they were available to prevent this type of violence. If you look at his actual tweets,
he didn't authorize the National
speeches
Guard on that
and
day.
Statements, he did.
Well, Cash Patel,
and
his former
Caitlin.
aide, testified that, and Cash Patel, his former aide, testified that as one of your witnesses here. But when he was asked for any, documentation or any evidence that Trump had done that, he didn't provide any.
Yeah, well, there were two. There was a second corroborative witness, Katrina Pearson, and in fact, the plaintiffs, they're called petitioners, brought in
but
a
Katrina
tweet
Pearson didn't
themselves
work in the White House.
From one of. Let me finish. Allow me to finish. A tweet from an advisor to President Trump, that actually referenced President Trump's efforts to make sure that to authorize the National Guard. I mean, it was their own evidence that they brought in that referenced that. So I don't think it's appropriate to say that he never authorized. That's just not fair. And I don't think the evidence leans in that direction. I thought we put on pretty strong evidence. And she can say she doesn't believe people, but just because there's not a specific written document doesn't mean that it didn't happen.
And there are written documents before that. Okay, we do have a notice that there was some verbal conversation about deploying the National Guard in D.C. How do we know that? It's because Mayor Muriel Bowser rejected them, right? She sent a letter back. We have that letter. We put it up on the screen many times here. She says, don't send National Guard into my city. So Trump was trying to do it on January 4th or 5th. She sent the letter on the 5th. It is in alignment that he would want it also going out on the 6th. Well, we told you, you want him now? And then they delayed, and we have Stephen Sund to corroborate the back end of that. Okay, so Trump was trying to be proactive before January 6th. Stephen Sund, former Capitol Hill chief of police, who got fired essentially after January 6th, confirms that on the back end, he was calling around for a bunch of stuff. Can I have permission? Can I have permission? Can I have permission? Delay, because they wanted it to happen. So the idea that Trump or the campaign, the Trump administration did something in the middle of that makes total sense as well. But they just pick little things and they say, well, where's the documents? Well, we got the letter from Mayor Muriel Bowser. Why didn't she accept it?
Frankly, part of the problem with this entire hearing was that we didn't even have the time or the ability to send out subpoenas and get this type of witness testimony and look at other types of documents to be able to make our case. So we were very limited on what we were able to do. So to be able to say, well, you didn't have enough documents, part of that was the truncated or compressed process, the lack of our ability to compel people to talk to us, the lack of our ability to actually get documents unless someone volunteered them to us. So there are some real problems along those lines.
Well, I haven't seen any
process itself.
I mean, this has been
we
a whole
thought there was
thing.
very strong evidence.
This has been investigated time and time again, including by this committee. And I mean, Donald Trump himself did not testify here. He blames Nancy Pelosi for calling the National Guard that day, even though it was in his authority. But I do, I looked at what you said on the first day of this trial. You said you believed the judge was biased and that she should recuse herself. Do you feel differently now based on this outcome tonight?
Well, I mean, what I said initially is she had contributed money to an organization that was specifically dedicated towards removing politicians that this group claimed, engaged in an insurrection. So the very purpose of the organization she contributed to was
before she was on the
had already
bench,
made
though,
a
right?
decision that showed her support.
But she was running.
Well, not quite. She had already applied, and I believe she had been nominated but not yet appointed. Plus, it was within the past year. So whether you're on the bench or not, if you do that
rules
within the
apply.
past year, usually attorneys sort of look at a year as a rough deadline for.
She knew where
sort
she
of
was
doing
going
things
when
in
she
the
did it.
past. And it was still pretty fresh. And so we had deep concerns about that. I'm not necessarily here to relitigate that about the judge. At the end of the day, we're respectful that the judge made the right decision. I understand she threw a lot of shade on President Trump, and we're not happy about that, and we disagree with it. But at the end of the day,
But I guess my question is,
and we're respectful of this, that she's respecting the democratic processes.
are you saying that you accept the ruling, but you're rejecting her findings here? It seems like you having it one way and also the other.
It's not actually. We'll see what he says, but we just went through the appeal. They're saying she didn't have jurisdiction to do any of this. Essentially, this case should have never gone, and they've been very consistent on that. And even in their appeal, he's making the point that we went to the Court of Appeals to say, hello, she doesn't have jurisdiction over any of this, and they just said, wait until it's over and consolidated. So no, Caitlin, they've been consistent from day one on this.
Not at all. I mean, we accept her her conclusion that the 14th Amendment doesn't apply to the presidency based on its plain text and the history as well. We certainly accept that. The other stuff she wrote in there, frankly, is not germane to her decision. Courts, attorneys will call that dicta. In other words, it's just sort of superfluous excess language that didn't really make a determination on how she ruled. So, at the end of the day, she said that. We disagree strongly with that, but she also ruled in our favor. And, at the end of the day, that's what we're satisfied about, that President Trump will have the opportunity, like everyone else, to make his case, and that voters will be able to have the opportunity to vote for him if they want to. And that's what democracy is about, and the judge respected that.
Right, instead of pulling him off like cheaters.
Still quite a scathing ruling saying that he acted with intent to incite political violence. Scott Gessler, the
intent to cite, yeah, okay. So, it's the same people, right? Why didn't Trump protect everything? Why didn't he protect the Capitol? I remember, if you rewind the clock, these were the same people saying, Trump is going to try to seize power. Don't you dare let Trump move the military into the Capitol or else he'll seize control. Right? And they were warning us like, oh, he's never going to leave the White House. And so if Trump moved the National Guard in, they would have said, see, he's trying to seize the country. So he's damned if he does, damned if he doesn't. And, this is CNN doing the usual thing, trying to beat up on that guy. He, in fact, handled himself very well there. And the appeal seems quite strong. It's like, why did this judge handle this case right now in this forum with these standards, with these issues at stake? Our right to vote for a candidate was almost stripped away from us by Colorado. And it still might be. We'll see what the Supreme Court does there. Trump's filings have been submitted, and they've got deadlines scheduled for more. So we'll be here continuing to cover it, my friends. Thank you for joining us. Thank you for subscribing and going to robertgovea.com to sign up for our daily newsletter. That's where you can get all of these segments, all of these PDFs that we just reviewed. You can access them and get the stories delivered to your inbox so you can forward them on to friends or family or anyone else who needs to know about this stuff as we continue to cover the Trump litigation here in detail. We'll look forward to seeing you on the next one. All right, my friends. Now, let's jump over to the Judge Chutkan courtroom and the January 6th case, because this is exactly what we'd expect. And I was pretty happy with my gifting here of Rachel Maddow. I thought that was a pretty good one. You know, that kind of like puppy dog face that she does. Anyways, let's get to it with Judge Chutkan. Donald Trump's motion to strike the inflammatory language out of Jack Smith's indictment is denied by Judge Chutkan, and that's not a surprise at all, because she denies most motions that are good brought by Donald Trump. But we're going to go through this one. It is quite short, only a few pages, but it's very curious because we're reading this in the context of Judge Chutkan's gag order. She's also said that Donald Trump cannot speak poorly about witnesses or about certain aspects of the case, and issued a very broad order, which is currently on appeal. And so we'll take a look at that. But this is her order saying that the inflammatory language that's in Jack Smith's indictment is going to stay there. In other words, Trump is gagged from talking certain types of language, from being inflammatory, but Jack Smith's inflammation, his inflammatory language, can be riddled all over the indictment. And the inflammatory language is also being used by people like Rachel Maddow, people like Clavicle Girl, who is saying that Trump is going to take over America. This is going to be the last election for all of us if we put him in power. Maddow is just melting down about fascism and other things. Goldman says we got to eliminate Trump. Of course, he later apologized for that, for using the word eliminate. And this former senator, Claire McCaskill, is saying that Trump is even worse than Adolf. And you go, my gosh, these people are totally nuts. So the motion to strike the inflammatory language is denied as it pertains to Trump. But this was Trump's original motion. And I wanted to share this with you. You see here, we've covered this one in full on a prior segment. But Trump is saying specifically here that the prosecution is seeking to try President Trump for crimes that the grand jury never charged, based on actions Trump did not take in a place he never was on January 6th, by people he never directed, and opposite to actions he actually did take in statements he made. All of that was language included in the indictment that doesn't relate to the charges, okay? So they keep calling him an insurrectionist who's undermining democracy, but they didn't charge him with any crimes that say you committed an insurrection or you did something to undermine democracy, right, as an example. So Trump submitted this, and this was a 17-pager. We read through the full thing. Of course, this is all going to be on the January 6th DC playlist on YouTube if you want to get caught up on all of the activities there. That is his motion. And now this is Chutkan's response. She says, all right, sorry, Trump, you are denied. Writing in a short 3 pages, not paying much attention to it, she says, you know, Donald Trump filed a motion to strike the inflammatory language from the indictment. They want to strike these paragraphs. They say that in those paragraphs, here's the language. Defendant, meaning Trump, and co-conspirators repeated knowingly false claims of election fraud to gathered supporters, falsely told them that Pence had the authority to and might alter the election results, and directed them to the Capitol to obstruct the certification proceeding and exert pressure on the vice president to take fraudulent actions he had previously refused. Okay, that's in Jack Smith's indictment. Trump says, gotta go, sorry. And that after that, supporters broke through the barriers, cordoning off the Capitol grounds, and then violently attacked law enforcement officers, and then breached the building. And that Trump, quote, refused to issue a calming message aimed at the rioters, which is what Liz Cheney wanted. She wanted to show up there and read all the FBI agents' bedtime stories. Hey, FBI, can you please stop attacking our Capitol? You're supposed to be protecting it. Instead, issued a tweet intended to further delay and to obstruct the certification, attacking Mike Pence for failing to halt the certification proceedings. But the court, through Judge Chutkan, will deny Donald Trump's motion. Big surprise, Judge. She says the federal rules of criminal procedure, they say that a court may strike surplusage language from the indictment or the information upon the defendant's motion. Trump has done that. That rule has been strictly construed against striking surplusage. So motions like the defendant's are highly disfavored in this circuit. That's weird, right? Federal rule says this. This is how the law works. It's the weirdest thing. The Federal Rules of Criminal Procedure says literally, this is the quote, a court may strike surplusage from the indictment. But that rule has been interpreted as being highly disfavored. Don't do it. Okay, so why is it a rule then? I mean, if you don't like it, just get it out of the rules. So they should be granted only if it is clear that the allegations are not relevant to the charge and are inflammatory and prejudicial. Well, they seem to be pretty inflammatory to us. Okay. Now, if an allegation is relevant or is not inflammatory, the motion should be denied. Now, okay, so we got some pretty strict rules. Like you can strike it, but it's a super high standard. It actually has to be inflammatory. Jack Smith's, of course, are not, as we'll find out. She writes, regardless of whether the allegations at issue are relevant against Trump, Trump has not satisfied his burden to clearly show that they are prejudicial. Okay, so everything in the indictment and all of the language that we're about to hear, this is bigger than just the indictment, by the way. It's the indictment, but it's everything. Okay, Trump gets gagged. Trump can't talk about this case. He can't call Jack Smith and the deranged thugs over there deranged thugs. But Jack Smith can put garbage in his indictment. Rachel Maddow can say whatever she wants. Clavicle girl, a witness in the J6 cases, can get on TV and say whatever she wants, essentially. And Trump can't respond to it because she's a reasonably foreseeable witness in the insurrection case. All right. Same with Dan Goldman and all these other people. They can hit the media as hard as they want, but the inflammatory language that is in the indictment has to stay. And even though the rules say it can be stricken, she says it doesn't meet the standard. Trump argues that sharing the allegations with the jury may result in prejudice at this trial because members of the jury may wrongfully impute fault to him for the actions of the Capitol on J6. They argue in their motion that the jury might decline to give Trump the benefit of reasonable doubt due to these extraneous allegations. It's statements that don't match the code. It'd be like if you got charged with a DUI and they made up a bunch of other stuff. They're like, by the way, yeah, this guy who also got, and you didn't even commit a DUI. You're like, right, you're just driving your car. And there's, yeah, this guy who got a DUI, they tell the jury, he also ran over a little old lady on the way to the grocery store where he was buying some more booze. And you're like, what are you talking about? I didn't hit a lady. And I was going to visit my grandma, not to go run her over. What are you talking about? They just kind of make it all up. And then they charge you with one crime that's not even true. And you go, what? All of that is not even related to the original charge. It's like if you ran over a little old lady, you'd charge that person with murder, but they didn't charge him with murder, just like they didn't charge Trump with insurrection. But consistent with its past practice, this court will not provide a copy of the indictment to its jurors, and so we're not going to prejudice them. And since we don't even give them a copy of the indictment, there's not going to be prejudice there. So it's like another technical thing. Saying here, right, referencing some case law, they tell us that Trump's 16-page reply, despite making numerous, oh my gosh. So Chutkan says, oh yeah? Trump? You are saying Jack Smith's indictment is inflammatory? Well, how about this, punk? You, in your reply motion, you make numerous inflammatory and unsupported accusations of your own, saying that President Biden directed the DOJ to prosecute his leading opponent for the presidency through a calculated leak to the New York Times. She says there's no truth to that and devotes only a single paragraph to the prejudice requirement, so doesn't show how Trump is actually prejudiced. Instead, his sole argument, Trump's, is that even if the jury does not receive a copy of the indictment, voluminous evidence exists here that the jury pool in this country, in D.C., has been and continues to be exposed to the indictment and its inflammatory and prejudicial allegations through the media coverage, which we're about to listen to, related to the case. And the indictment gives the media cover, right? They say, no, they say Jack Smith is indicting him for insurrection. but he's not charged with insurrection, but it's in the indictment, right? It's fake. But the defendant fails to cite even one example of that evidence. In any event, they say the voir dire jury selection process will allow the court to examine and address the effects of this pretrial publicity, including anything generated by Trump that it's had on the impartiality of the jurors. And when trial begins, the court will also take steps to screen the jury from any irrelevant and other prejudicial material that either party seeks to introduce. So the judge is saying, I'm going to protect all of this. When trial begins, we're going to protect the jury, which is so weird, because if the judge can screen the jury about irrelevant and prejudicial material, can't they also do that for Trump's gag? Like, why does Trump need to be gagged and undermine the legitimacy of the Justice Department, which is part of their argument? They're not just saying Trump can't speak because it might lead to harm, because there really has been no harm for evidence that they've been able to show, but that Trump is undermining the legitimacy of the DOJ. Well, can't they just voir dire that out then? Can't the judge just deal with that in jury selection? Why does she have to gag him? She's just going to screen the jury. Well, just ask the jurors. Did you hear Donald Trump say anything bad about these deranged thugs here? Oh, you didn't? Oh, great. So she gags him because it's about the political battle, right? She wants him to not be able to speak. It is straight out of a totalitarian psychoville. Now, moreover, before the jurors deliberate, the court will instruct them on the actual charges and the evidence that they may consider. But apparently that's too much to ask for Trump's free speech. Now, this too will prevent potential prejudice from the alleged surplusage. And so therefore, for the reasons as the judge stated, the motion to strike the inflammatory allegations from the indictment is hereby denied. Thanks, Judge. Yeah, real great legal analysis there. And we all expected that to happen. And we're going to see a lot more of this stuff. All the other motions are going to be denied. But they're making a record, and we'll see what they decide to do from here. But Chutkan is, as we saw, gagging Trump. She's going to correct the problems from their side. Like if Jack Smith talks a bunch of garbage, she'll fix that in voir dire. He's allowed to do that. People like Clavicle Girl, who's a J6 witness, is allowed to talk about all this stuff. But Trump can't, because we're living in a double standard world now. Now, I'm going to go through a couple clips here today. We've got Rachel Maddow, who is basically having a meltdown, and she'll start us off here to get things warmed up.
So the American fight against fascism, juxtapose that against what Trump is doing. You have studied this topic extensively, and you cover the current news. Are you scared, Rachel?
Rachel.
I sort of feel like we don't have time to be scared, Steph. I feel like there's a lot to do. I mean, it's hard to be a 250-year-old democracy. It's hard to be a democracy. I mean,
what happened? What did we not do in the previous 250 years? Oh yeah, prosecute our political opponents in this country. Now we're doing it.
Always people who are pushing against it. And right now, the most powerful force in conservative politics is pushing really, really hard against it. And part of the way they want us to get there is some variant of a civil war. We don't have time to worry about it if that's going to preclude us from working against it. And time is short and the river rises. Now's the time, if you're worried about it, to get involved.
Yeah, get involved, everybody. All right. So I am so glad that clip was only 50 seconds. I am so glad. I don't think I could have gone a full minute. I really don't. I don't know what I would have done if that lasted even 10 seconds longer. So we made it. That's the hard part. All right. Let's see. This is also just as hard, actually. Brace yourselves. So this is Clavicle Girl. Now, Clavicle Girl would presumably be covered by Judge Chutkan's gag order because she's a J6 witness. She was brought in front of Liz Cheney to talk about Trump, theoretically, reaching over the Secret Service vehicle in the aftermath of January 6th, reached over the Secret Service, grabbed a Secret Service agent driving the vehicle by the clavicle, her testimony, and tried to get the vehicle to go back into the Capitol. Trump's like, "Wah!" And Melania was on a helicopter hanging from the ladder, the rope ladder, like Ethan Hunt from Mission Impossible. And I don't know what the Trump kids were doing, but I know that there was a lot of activity that day. So she was called in front of Liz and Kinzinger, And now she gets to show up on Inside Jen Psaki, MSNBC's hit show, and rant about Trump, and Trump is gagged against responding in America? What?
What would you tell those of your former colleagues who are concerned but haven't come out publicly about the importance of doing that at this point in time?
I think and the Washington Post put out a good story today about that, Jen, and there are a few particular quotes that stuck out to me, but towards the last half of the article, there were former Trump aides, anonymous former Trump aides, but I will point out that they were given masculine pronouns. So, namely, primarily men who were speaking with the Washington Post anonymously about how they might want to speak out if he is the nominee, or they don't think it's worth speaking out because they'll lose clients. And what I'll say to them, I do understand a fear of retribution. I do fear backlash. I do understand their fear of backlash. But when we think about this next election in 2024, I don't like to play a doomsday hypothesis, but it does look like he is going to be the Republican nominee as of right now.
You better believe it, baby.
If Donald Trump is elected president again in 2024, I do fear that it will be the last election where we're voting for democracy, because if he is elected again, I don't think that we'll be voting under the same Constitution that we would be if Joe Biden is elected in 2024.
Yeah, so she's on Team Joe now, which is very curious because she's hanging out with Inside Jen Psaki. Now, this is a curious exchange because she is a witness, right? She's actually talking badly about Trump. So what if Trump were to hop on Truth and say Cassidy Hutchinson is a demented weirdo, right? Or something like that. What a demented weirdo. I would never do anything to the Constitution. I love the Constitution. In fact, I'm the one who adhered to the Constitution. My side, people on the right, were asking Trump to prosecute Hillary, and I didn't do that. I didn't shatter the norms of prosecuting my political opponents, but their side has done that. And so if Trump were to say something like that, that would be in violation of the gag order. She's a reasonably foreseeable witness. She was there as an aide at the White House in some minor capacity, and now she's hanging out with Psaki, and kind of, sounds like sounding the alarm. And so Trump can't talk about this. He's gagged. And this type of inflammation out of MSNBC is allowed to permeate the airwaves? Well, apparently. Dan Goldman can also use worse language than anything Trump ever said. Trump said things like fight like heck. And Dan Goldman shows up also on Psaki's show, who's hysterical about all this insurrection stuff. And he says this, and Jen Psaki let it slide.
I want to also turn to Trump, of course, and just some of what the reporting has been around some of his conversations, also as we anticipate a year full of trials next year. I want to take a listen to part of a conversation that he had with ABC's Jonathan Karl about January 6th and get your thoughts on the other end.
You told them you were going to go up to the Capitol. Were you just...
I was going to, and the Secret Service said, you can't. And then by the time I would have, and then when I got back, I wanted to go back. I was thinking about going back during the problem to stop the problem, doing it myself. Secret Service didn't like that idea too much.
So what?
I could have done that, and you know what? I would have been very well received.
So there's been so much speculation, contemplation, discussion of what Trump wanted to do, what he knew or didn't know. I mean, do you think as a prosecutor, former prosecutor, this is something that could be useful in the case against Trump? How will it be used?
Former prosecutor?
Yeah, well, I mean, look, he says I would be well received because he knows that the people who were there are his supporters who he riled up and incited to invade and riot at the Capitol and try to disrupt the proper counting of the Electoral College votes. So every time he talks, he's putting himself into a bigger criminal hole. But that's not his objective. His objective is purely political at this point.
Because that is the only mechanism that exists in a democracy. These people are so dumb, they don't even understand why we have the First Amendment. The First Amendment is to be able to speak openly, rally support to your cause, to challenge what your argument is, a corrupted government. When the government has become corrupted, or when the people in power who are in current control of the government are corrupted, they have the power. They have the DOJ. They have the FBI. They have all the jurisdictions that they're bringing these charges in. like Washington, D.C., for example. They have it all. So you have to talk out politically about this. This is natural. This is a healthy thing, right? If Trump were prosecuting people, you better expect that people would be saying, wait a minute, what? This is shattering 234 years of precedent. But he never did that. They did.
Politics don't work in a courtroom, as I think he's finding out in the New York Attorney General's case in New York, a civil case, and that's going to continue in his criminal trials. But his rhetoric is really getting dangerous, more and more dangerous. And we saw what happened on January 6th when he uses inflammatory rhetoric now. 2.0. And his recent Truth Social post is incredibly, incredibly scary for anyone that might be trying to work in government. And it is just unquestionable at this point that man cannot see public office again. He is not only unfit, he is destructive to our democracy, and he has to be eliminated.
What? Eliminated? That sounds pretty bad, Dan. Sounds like you might be arguing for a crime. Maybe stochastic terrorism. What if somebody does something against Trump? What if Trump gets a bad email? What if there's a bad phone call? What if somebody listening to Inside Jen Psaki's show sends a mean tweet and Trump gets harassed? This is a congressperson calling for the elimination of a former president and a presidential candidate nominee, the leading contender, calling for him to be eliminated. And look at his little smirk there. He knows what he did. He's not a dummy. One more time.
It is just unquestionable at this point that man cannot see public office again. He is not only unfit, he is destructive to our democracy, and he has to be eliminated.
Yeah, he even thought about that word. You could say defeated, beaten at the ballot box, but he chose eliminated. Now, of course, he did apologize for that. He's like, oh man, this is pretty bad. I just committed an insurrection in America. He's like, I've been screaming for Trump to be prosecuted over this thing, and I just did it on Psaki's show. He says, yesterday on TV, I mistakenly used the wrong word to express the importance for America that Donald Trump doesn't become president again. While he must be defeated, there you go, got it, Dan. I certainly wish no harm to him and do not condone political violence. I apologize for the poor choice of words. Well, we still don't like it, Dan. So thanks for the apology, but no thanks. So this is former Senator Claire McCaskill also doing the same thing, right? These are like former government officials and other government officials like Dan Goldman, other Congress people, other actual witnesses. Everybody's allowed to talk inflammatory language about Trump, but Trump is gagged, and Trump can't even respond to court documents, even though the rules say he can. But this is Claire McCaskill, who is now arguing, and pay close attention to the language she uses, but she says, you know, these people are bad, like Adolf is a pretty bad dude, but Trump is worse, okay? What's even more concerning about Trump? So, you know, like Adolf and these people like over here. But then there's Trump, man, and it's bad.
A lot of people have tried to draw similarities between Mussolini and Hitler and the use of the terminology
Bad
like
dudes.
vermin
Bad dudes.
and the drive that those men had towards autocracy
Yep.
and dictatorship.
But
the difference, though, I think makes Donald Trump even more dangerous, and that is he has no philosophy he believes in. He is not trying to expand the boundaries of the United States of America. He's not trying to overcome a neighboring country like Putin is in Ukraine.
Or like Adolf
he is
was.
not going for some grandiose scheme of international dominance. All he wants is to look in the mirror and see a guy who's president. All he cares about is selfish self-promotion.
That's worse than Holocaust? What?
That's the only philosophy he has, which makes him even more dangerous because he has actually said out loud that it would be okay to terminate the Constitution to keep him in power. He said this. He actually said those words. No! And the irony is all of these supposed conservative folks that have populated the Republican Party all stood around and with their thumb in their mouth going, well, yeah, okay, I guess so. It's bizarre.
Oh, man, it's going to be a weird Thanksgiving dinner with her at the table, isn't it? Look at her, man, the head bob and everything. She's just going, oh, he's so the Constitution. It's like, lady, do you realize what your party is doing? What Constitution? You've wrecked free speech. You're trying to undermine the Justice Department, the justice system in this country at every turn. And you have this claim now that Donald Trump, hey, by the way, can I just, self-interested people oftentimes do a good job at certain roles, because if you're a good president, then that is good for your legacy, right? It is good for the Trump brand. It is good for the Trump reputation. If Trump gets in and he does a good job for America, yes, it's good for America. It's also good for Trump. We're in alignment. The interests are aligned. The problem is when you've got somebody like a Biden, for example, where what's good for the Bidens is not necessarily good for America, because you've got the Chinese pumping money into Hunter and James and Sarah and Hallie and the rest of them, right? So it's when those interests are disaligned, when they're self-interested rather, I would say, let me say that, a little broadly, like when the self-interest misaligns with the American interests, that's when you have a problem. But if they're in alignment, that's a great thing. But apparently that's worse than World War II and like 60 million dead. So, all right, well, we'll figure that out. Hopefully her family brings some extra wine this Thanksgiving for them. And so it's a strange situation where inflammatory language can be thrown in indictments, where even witnesses can hop on mainstream media, badmouth and belittle and slam the opposition. But Trump is gagged. Trump is limited by the judge from even removing some of the surplus language that is not even relevant to the charges from the document. And they sit around pretending like this is actual justice in America. And anybody else who challenges them is undermining the legitimacy of the institution. Nope, they're doing it themselves. We're just here observing and defending against what they're trying to do, which is wrecking the once sacred principles of due process, presumption of innocence, free speech, and so on. But we'll be here continuing to cover, my friends. Thank you for subscribing. Thank you for going over to robertgovea.com to sign up for our daily newsletter. That way you get these show reports all delivered to your inbox, and you can share those with friends and family, and we'll be looking forward to seeing you and them on the next one. All right. And now we got one final segment on the day, and this one involves old Hunty Poo. And we're looking forward to this one. Hunter Biden had an inside person at the DOJ allegedly warning him in his defense about possible investigations into storage facilities and other locations. Turns out that person, that inside person, that mole might be used, the phrase, is Lesley Wolf, the DOJ prosecutor and a major Obama donor. She is getting a subpoena courtesy of the Judiciary Committee and Jim Jordan as part of the investigation into the cover-up, into the Biden crime family cover-up and the criminality. And so we're going to go through the full subpoena. We're also going to see what James Comer says about his investigation into the Biden crime family, the current status of that. But before we do, who is Lesley Wolf? Who is this person who is responsible for being involved in the Biden crime family investigation for many, many years? This is the story that comes to us from heavy.com. 5 facts that you need to know about Lesley Wolf. Written October 17, 2023 by Jessica McBride. Great story here. And this tells us that she's an assistant U.S. attorney who featured prominently in testimony, and we've covered a lot of it here. Comments about Wolf came from testimony from the whistleblowers, Gary Shapley and others. But if you look in her background, campaign finance records show that Wolf and her husband are Democrat campaign donors. FEC commission records show that her husband donated to Obama 14 times. And Lesley donated to Act Blue, a Democrat fundraising operation. Her donation was earmarked for Amy Klobuchar. Lesley Wolf, according to Open Secrets, also donated to Josh Shapiro, Democratic governor of Pennsylvania, and also worked for a Corona coordinator in the U.S. DOJ. She previously clerked for a federal judge for George H.W. Bush. She's 48, also mentioned in separate testimony from a second IRS whistleblower. They described the other whistleblower, they described her as the U.S. attorney in Delaware. According to her Pennsylvania law license, her name is Lesley Frieder Wolf. She's assigned to the DOJ, admitted to practice law, Pennsylvania, 2006. Husband is a physician, is a psychiatric professor, and they have a wedding announcement in the New York Times. She says, I'm the whistleblower. According to Shapley, he said, I'm blowing the whistle that the Delaware U.S. Attorney's Office, the DOJ, and the Department of Tax provided preferential treatment to the president's son. Full transcripts were released. But here's what you need to know. A wedding announcement says that Lesley and her husband, they were studying neuroscience when they met. So sounds like a sharp dude. So more about this. They are Democrat donors. So here is a dono from Lesley Wolf, U.S. Department of Justice year to date, earmarked for Amy Klobuchar. Right there is the dono. 2022, she made a dono to Josh Shapiro, and her husband donated to Obama 14 times. $1,175 in different increments. $100, $200, $100, $100, $100. Obama for America, 2012, 2008, both campaign cycles. 25, 25, probably a recurring thing. And then as the election nears, he bumped it up to $100 and then to $200 later. Now, according to the FEC records, Lesley donated $50 to Amy Klobuchar, and $100 is this one. And here's another one. In 2019, she sent some money into Gifford's PAC, which I believe is another Democrat there. Daniel Wolf in 2017 and 16, they each donated money to Americans for Responsible Solutions, and Daniel Wolf gave some other money to another organization. Also, according to Influence Watch, Giffords, the Giffords PAC, to elect supporters, that's here in Arizona, of gun control to public office, right? Gun control. We also have this. Lesley Wolf is accused of telling investigators that optics were a driving factor in whether to search Joe Biden's guest house. And she's accused of tipping off Hunter's lawyer about a pending storage unit search. And so we're going to go into the letter here in a minute. This is just a little bit of backstory. And Shapley has a lot of testimony. She prosecuted fraud cases in Delaware. So she's also been somebody who's been in Delaware. And so a nice Democrat. It says a judge, Lesley Wolf, clerked for a judge who was appointed by a HW. So not that she was appointed by HW, but she worked for a judge that was appointed by HW. She's a donor to Columbia Law School, and that's her background. Okay, now that we know a little bit more about her, she is now getting a subpoena. And this is what the Judiciary Committee sent over to her, and coming from the Judiciary Committee, our friend Jim Jordan, who is leading the charge here. You see Jim Jordan from Ohio sends this letter on November 21st to Miss Lesley Wolf, and it's going to the U.S. Attorney's Office in Delaware. So this is fun. Congress is subpoenaing a U.S. attorney now. They say, Dear Miss Wolf, the Committee on the Judiciary, Jim Jordan, is conducting oversight of the executive branch and your commitment to so-called impartial justice. We're also investigating the veracity of statements that were made in response to congressional inquiries related to the DOJ's investigation of Hunty. Our committee is also investigating whether sufficient grounds exist to draft articles of impeachment against President Biden for consideration by the full House. Along with the House Ways and Means Committee, Jason Smith, and Oversight Committee, James Comer, we set forth memorandum of evidence justifying the scope of an impeachment investigation. Now, as part of our investigation, our committee has determined that we require your testimony because you have firsthand knowledge of the department's criminal inquiry of Hunter. In light of the department's refusal to make you available, we tried to go through the DOJ and your bosses, but they are not making you available. We asked for a voluntary transcribed interview. We have no choice now but to compel your testimony at a deposition. So get ready. On June 29th, the committee, along with the Ways and Means Committee, sent a letter to Merrick Garland asking that he allow several DOJ officials, including you, Lesley, to sit for a transcribed interview. Here is what we sent. The department did not comply with our request. On July 21st, we reiterated our request, and again, the DOJ did not comply. Shocking. After additional communications and attempts by our committee, Congress is trying to be a friendly entity here, the department finally made 6 employees available for these transcribed interviews, although there were substantial scope limitations. So they did talk to some people, but our request for your testimony, Lesley, remains outstanding. And there's a big question mark on that one. Why did those 6 employees, why were they okay, but Lesley's is not? Is it my ongoing investigation? Nonsense? Now, based on the committee's investigation to date, Congress says, it is clear that you, Lesley, possess specialized and unique information that is unavailable to the committee through other sources and with which our inquiry would be incomplete. They say witness testimony and public reporting indicates that as the Assistant U.S. Attorney for the District of Delaware, Lesley, you were directly involved in that office's investigation of Hunter Biden, which deviated from standard investigative procedures. Why? For example, among other things, according to whistleblower testimony, Lesley, you attended a substantial majority, if not all, of the prosecution team meetings concerning Hunter. Information that's available to the committee tells us that you, either directly or by instructing others, are responsible for many of the decisions to deviate from standard investigative protocol during the investigation of Hunter, including, apparently, Lesley, you told defense counsel about a potential search warrant for Hunter's abandoned storage unit, and then you later objected to executing the search warrant on the storage unit. And that comes from Gary Shapley and also from Joseph Ziegler, literal special agents at the IRS, 2 of them. They both said it. 2 of them corroborated. Why did you do that, Lesley? You also prohibited investigators from asking witnesses about the big guy, or quote, dad, presumably referring to President Biden. That came from Shapley's interview as well. How come, Lesley? You also ordered investigators to remove from a search warrant any reference to, quote, political figure 1, which is President Biden. Don't talk about him in your criminal documents. Get him out of there. You also prohibited investigators from following up on evidence of criminal campaign finance violations. Why did you limit their scope? You also forbid investigators from interviewing Hunter's adult children. So, Lesley, according to witness testimony, you obstructed. Uh-oh, we're getting into maybe some criminal territory here. You obstructed the U.S. Attorney's Office for the District of Pennsylvania from briefing the District of Delaware about information from a highly credible confidential human source about bribes that were allegedly paid to President Biden and to Hunter. How come you did that, Les? Now, the former U.S. Attorney for Pennsylvania, he testified that you served as the primary interface for your office to receive information about the Biden family bribery allegations. So she's the choke point. He explained, and I don't know who this person is. This is a new player enters the game, the U.S. Attorney Office from Pennsylvania. So he must have been one of these people that was allowed to be interviewed. He explained that the information sharing between the 2 offices became so constricted that we had to provide written questions to the investigative team in Delaware, almost in the form of interrogatories, and then we receive answers back. Wild. So, in other words, she's the choke point, right? Everything comes over. She says, let me ask them, like, okay, what do you guys need? Okay, write me the list of questions. Nope, that's not, you're not getting that. Nope, not getting that. Nope, not getting that. Okay, they can answer these. Gross. You also attended a briefing in October 2020, where the election is happening, about the bribery allegations after the Associate Deputy Attorney General, Richard Donahue, ordered your office to receive the briefing. Now they say, all right, Les, These facts, as well as others, are laid out in more detail in our impeachment inquiry memorandum, which we're sure you read. And given your central role in the DOJ's investigation of Hunter, you are uniquely situated to advance not only our oversight and our potential legislative reforms, but also to fill out our impeachment inquiry. Now, we've sought repeatedly to obtain the DOJ's voluntary compliance with our request for a transcribed interview with you, and we've engaged in good faith with the department about the purported reasons why it could not comply. And that's our question. How come? Although the department has allowed other employees involved in the Hunter investigation to testify, albeit with substantial scoping limitations, the department has not agreed to make you available voluntarily at all, which is their mistake. Now they're going to get a subpoena. The department's reasons for not allowing you to provide testimony are unpersuasive. Without specifically referencing you, Lesley, they have generally claimed in correspondence that it's a long-standing policy to not make non-Senate confirmed and line-level DOJ employees available. So she's just not available because she's too low. Now, as we've repeatedly informed the department, this claim is actually factually, legally, and historically inaccurate. Footnote 22. They said, no, we sent you a letter on this. We've already explained. We interview these people all the time. Congressional committees have regularly received testimony from non-Senate confirmed and line-level Justice Department employees. The nonpartisan Congressional Research Service, after examining 90 years of precedent, concluded that investigating committees have often obtained testimony of subordinate DOJ employees like line attorneys and FBI field agents, both formally and informally, on specific matters of DOJ operations. Sorry, guys. Here's this document. Happens all the time. Indeed, the committee has conducted interviews with line level and other non-Senate confirmed department employees of oversight before, and we seek the same thing from you now. And further, our committee also requests and rejects the department's amorphous assertion that, quote, an ongoing investigation prohibits Congress from exercising its constitutional oversight obligations. As the department well knows, there is no, quote, ongoing investigation privilege codified in statutes or recognized by the courts. Your claim rests on no constitutional privilege or case law authority, but solely on opinions issued unilaterally by the DOJ. Right? The DOJ writes their own memo, and then they reference their memo. They're like, oh, sorry, it's the policy. We're like, yeah, well, we know it's your policy, though, but even I am not above the policy. Says, in fact, there is ample legal and historical precedent that's even contradicting the department's assertion. That is, precedent of congressional committees conducting oversight of matters that are subjects of ongoing investigations. The historical record is replete with examples of DOJ providing information related to ongoing criminal investigations to congressional committees. Do it all the time. Including the exact type of information that the committee is looking for in this investigation. The suggestion that the department may somehow dictate the nature of our oversight because of this never-ending, ongoing, continuing nature of an ongoing law enforcement investigation lacks any valid legal basis, and the committee does not accept it as legitimate or any reason to obstruct or otherwise to delay our efforts. Jordan continues. He says, the Supreme Court has recognized that Congress has a, quote, broad and indispensable power to conduct oversight, and pursuant to our power, that's what we're doing. We're considering reforming the special attorney statute, codifying special counsel regulations, and reforming the tax division. They say we also, according to the Supreme Court, may seek information about the executive branch where there's corruption, maladministration, inefficiency in the agencies in the government. And here, whistleblowers, Lesley, have brought forward numerous allegations of corruption. For example, presidential treatment of the president's son, maladministration, retaliation against the whistleblowers, inefficiency, things like an investigation being so bogged down by delays and micromanagement that statutes of limitations have lapsed before prosecutors could even file the charges. All of this, backed by contemporaneous documentary and testimonial evidence, these are among the matters about which the committee requires testimony. And so, finally, as part of the impeachment inquiry, the committee is investigating whether Biden abused his power as president to impede, to obstruct, or to otherwise hinder the investigations, including our congressional investigations or the prosecution of Hunter. Now, Lesley, given your critical role played in the investigation of Hunter, you are uniquely situated to shed light on whether President Biden played any role in the DOJ investigation or whether he attempted in any way to directly or indirectly obstruct either the investigation or our investigation, whether he interfered with the DOJ, the Department of Tax, or anyone, or whether he's interfering now. And so, Lesley, accordingly, for all these reasons, and in light of the department's non-compliance with our earlier voluntary requests, please find attached a subpoena compelling your appearance at a deposition. Ooh, that feels good. We've been waiting for that one, man. Lesley Wolf has been in this show for a lot of episodes and a lot of time. And this comes from Jim Jordan. Sincerely, your friend. We'll see you at the depot. Jim Jordan. That is over from Congress of the United States, the Committee on the Judiciary, signed by Jim Jordan. And that's going to be fun to see what they do in response to that. But we've got James Comer, who has been at the forefront of the Biden crime family inquiries for quite some time, is here. And he's got something to share about the investigation because he's on the Oversight Committee, and the Oversight Committee is leading the charge along with the House Ways and Means Committee. And we're going to see if this video loads up. Otherwise, we've got a little bit of a backup plan here. We'll just see which one loads first, and we'll go with it. Oh, this is a bigger video. It's a bigger video file. That's why it's taking a minute to download. It's a longer one, but we'll just hit the highlights. All right, here it is. James Comer.
Welcome back, House Judiciary Committee Chairman Jim Jordan sending a subpoena to Hunter Biden prosecutor Lesley Wolf. Wolf, who was ordered to appear before the committee on December 7th, is accused of trying to shield President Biden from certain questions and search warrants related to the Hunter Biden investigation. This just days after the White House vowed to fight all subpoenas of the Biden family members. Special counsel to the president sent a letter to Republicans accusing them of misrepresenting the facts and urging them to withdraw all subpoenas and requests for testimony. Joining me right now is Kentucky Congressman, Chairman of the House Oversight Committee, James Comer. Mr. Chairman, thanks very much for being here this morning.
Good morning.
So you heard what the White House wants. They want you to withdraw all of these subpoenas, stop asking any family members to testify publicly or under oath. Your response?
Well, no one's misrepresented the facts more than the White House, more than Joe Biden. I mean, if you look at this investigation from the very beginning, all the narratives pre-investigation have been proven to be false. We found that the Bidens had 20 shell companies. We found that 10 Biden family members have received funds from foreign nationals all over the world. We've proven that the Bidens have received over $25 million from these foreign nationals, and they can't explain one single thing they did to earn the money. We've proven over and over again that Joe Biden hasn't been truthful with the American people. Because of our credible, substantive investigation, focused mainly on bank records. And remember, bank records don't lie, Maria, as you know. We now are in the deposition phase. We have specific questions for Biden family members and people associated with the Biden family members about specific transactions. We want to know what these companies were and what the Bidens did to receive the millions and millions of dollars from our enemies around the world. So the White House shouldn't be surprised that we've reached the point now to where we want to bring these people in and interview and or depose them about specific questions about very suspicious and shady bank transactions.
So do you have any expectation that the White House is going to stop these testimonies? I mean, James Biden, the president's brother, is expected to testify before your committee in 2 weeks on December 6th. Hunter Biden is expected to testify a week later on December 13th. Do you think these are going to happen?
Well, if I were one of the Bidens, I would want to come defend my good name. I mean, every time I brought something out, Maria, many times on your show, the White House has attacked me and claimed that I misrepresented the facts. Well, now here's their opportunity to set the record straight. We have their bank records. They know we have their bank records. They know we have email correspondence. They know the laptop was real, despite the fact that they worked with the intelligence community to say it was Russian disinformation to peddle a false media narrative. They know everything that we have, and they can probably guess 95% of the questions that we're going to ask. So this shouldn't be a very difficult thing for the Bidens to come in and tell the truth.
Yeah.
And I expect them to come. And I can tell you, Maria, after speaking with Speaker Johnson last week, both Jim Jordan and I have confidence that if anyone does not obey our subpoenas, that Congress will then react to hold these people accountable.
Good.
This investigation has been very transparent from day one.
Yeah.
We've told people we were going to follow the money. The whole purpose of the investigation was to determine whether or not Joe Biden had lied to the American people. We know the answer to that. He has many times. The second purpose is to determine whether or not our president is compromised by our enemies around the world because of the millions of dollars his family's received.
And it's a very dangerous moment in
All right, so we can see that this is the current status, and I like it. I think that it's very nice that James Comer is saying we're going to have some repercussions if they don't show up. Now, will they show up? I think the smart play for them would be to show up and to try to play ball and to try to limit it and to say, oh, we had a great depo, nothing came out of it. But I'm not sure if that's going to happen or not. And if they don't show up, we'll see if Congress holds them in contempt or where it goes from here. But my friends, we will be here continuing to cover it. And I hope you join us as we do. Thank you for subscribing. Thank you for checking out robertgovea.com to sign up for our daily newsletter. If you want to access the mind map, you can do it there. You can also access all the PDFs. Everything we go through is at robertgovea.com. So if you want to catch the red lines or share a segment with a friend or family member, we'd love to see you there and here on the next one. All right, my friends. Well, we covered some good ground today, and Hunty and Lesley getting a nice little Thanksgiving memo before they break for the holidays. We've also got Chutkan, as expected, denying Trump's requests, his request to strike the inflammatory language from the indictment. Of course, the gag order is still on appeal. And then Trump is also appealing the Colorado insurrection case because the other side is appealing it. And we'll see what the Colorado Court of Appeals does on that one when the briefing is scheduled in December. But now, my friends, it's time to hear from you. I see we got some amazing, very generous, and very welcomed super chats and donos in from our friends on YouTube, on Locals, on Rumble, and I'm grateful for those. Let's see who is in the house on this beautiful day, starting us off. It looks like we got some Dolphin fan is the man activity kicking us off. We also got, oh, hey, what's up? David Reese also became a supporter. What's up? Welcome, David Reese, as a supporter. And Dolphin fan bringing in new membos. Debbie W, Diane B, heard, not seen is coming in. We got L's here. And Pope Rackets touched me is coming in, courtesy of Dolphin fan is the man. Dolphin, thank you for that. Happy Thanksgiving to you and everybody. Glenn Croy is bringing in 5 membos. Danny M, Roberto G, Helium Hub Crypto Collective, sounds cool. Will Call Magic and Tyrannus S is in the house, courtesy of Glenn Croy. We got a lot of membos coming in. Tony Hay Munkets is bringing in new membos. That's like 20 membos, man. Lil old me is a membo. Colin S, Bill L, Selly's here. Renee C, Calbo D, Peter R, Southern Comfort, Mike Martin, and Maz J is in the house, courtesy of our friend Tony Hay Munkets. Tony, thanks for bringing in the new membos. And hey, new membos on YouTube. If you want to join us for the members only after party, you can do that. But you got to grab the Telegram link on the tubes on YouTube. Go over to the community tab section, scroll all the way down, grab the private Telegram link, and we'll see you there for the after party. Nikki Perez Says, happy Thanksgiving, Robert. Appreciate you. 1 month left till we got a baby. Woo! All right, Nikki Perez. It's good to see you. And man, we're going to have another little watcher just roaming around here next month, any minute. Any minute, another newborn. Nikki, thanks for being here. Thanks for the nice dono. Happy Thanksgiving to you. I appreciate you being here and being part of the show. We got Pinecone. What's up, Pinecone? Bringing in one new membo, Drew M, coming in, courtesy of Pinecone. Pinecone is also a membo. We appreciate you, Pinecone. Thanks for that. Tony, hey, 5 new membos. JDM, Flyvelli is in the house. HD, Marius B, and Chris C, all coming in as membos, courtesy of Tony Hay Munkets in the house. The Rubos are here. And of course, I don't know what kind of salt you're having with your Thanksgiving this holiday. A little too late to probably order some Rubos Salt Shop if you don't have it. But Christmas and the holidays are still on, so you can go over there to rubosaltshop.com. They say, happy Thanksgiving to you and your family, Rob, and the Watching the Watchers family. Happy Thanksgiving to the Rubos. Say, sending love and light and prayers for a very happy Thanksgiving. This one is from In My View, says, I missed the whole stream. And it looks like there's a bunch of kitties in that image. I missed the whole stream. I don't know what's going on in that image. So, it seems like ominous. So I don't know what's going on in there. But I don't know what happened there. Spud says, Rob, the Rubos earlier were quoting a lawsuit I've been sending you the information about, where the appellate division was saying that the state of New York, we the people, the rest of the country can be quarantined regardless of origin. Thank you, Spuds. And thanks for sending that over via email. I appreciate it. NY says, there are several strong arguments for Trump. However, the one that prevents his name on the ballot is too preliminary. We don't know if Congress could vote to remove any disability, and remove any disability he could have, so we cannot know, and he must remain. Fred is here, says 2K away from 300,000 subs, Rob. Woo! Been here since 30K, man. Fred, that's a long time, man. That's a long time ago. And we're getting close. Yeah, we're getting close. We're getting close to that 300 number. And we're super excited about that. So if you haven't already subscribed out there, I'd love it if you did. And we're getting close, inching day by day. I swear I don't check it like every day. I swear I don't check it like obsessively. I swear. NY says, a judge is in a liberal area. She threw her libs a bone with the insurrecting finding. Insurrection is a criminal charge, not civil. She had no jurisdiction to confer guilt of any fashion in the matter before her, which is right. It's like, what is she doing? What was this whole thing? It was just like a fantasy land. It was an election case that turned into like a criminal trial for some reason. James Gass is here, says, happy Thanksgiving, everyone. I love the way you break all down for people like me. Law for dummies. Well, I would never call you a dummy, James. I think that you're probably very astute since you're here on this show, on this channel. I think you're probably smarter than the average bear out there since you're here. But I do understand what you're saying. We do kind of, break things down here and simplify it and cut through some of the noise. We like to fast forward here is really how I'd say it. And I'm grateful that you come and join us. It is your first super chat, James. And so it's the big one. The first one's always the hardest. Sometimes the first time's a little weird too, So I'm glad you did it. Hopefully you're feeling good about it. Hopefully you come back and we get to do it again. We got this one from Mia Tamama. Mia Tamama says, hi, Rob. Can we make courts more, quote, real time? Can we make courts more real time? A membo for 2 months. Well, I mean, if we could live stream it, like if they could actually live stream it, then it's exactly real time. But a lot of the things that we cover are not. A lot of the things we cover are actually not even broadcast because they're federal court proceedings, which is a bummer. I wish they were. I wish we could cover it all live, but thanks for being a membo for 2 months, man. We got, hey, 1917 Beamer says, Ronna needs to get off her duff and send a team of lawyers out to take care of problems because the Dems are planning to take 2024 again. I don't doubt it. NY says what she's saying here in the court opinion is just dicta. It has no force of law. She is a civil court judge. She isn't an Article 3 court. Rocky Water says, geez, Rob, Trump's lawyers asked a lot of questions to the judges in their appeal motion, but they were all such easy questions. I mean, I answered nearly every one of them on the first try, and I'm just the layman. I'm thinking about the bar exam. These lawyer questions are easy. I know. It's like, what do we even do? If you guys only knew what we actually did, you're like, oh, gosh, you're a lawyer? Actually, I think most people think that anyways. Oh, gosh, you're a lawyer? Yeah. We got this from NY says, this ruling needs to be challenged because she found him guilty of insurrection, but finds that the 14th Amendment does not apply to the president. What if someone files another lawsuit about conduct when he isn't president? It could give liberals another go round. NY says their witness testified on cross that Trump executive branch is not responsible for security. The fact that Patel offered is more corroborative evidence for Trump. Okay. We got this one from Knox Bierman says, Paxton is suing our friend Pfizer. Ooh, that looks interesting. Thank you, Knox, for the heads up on that. Knox says, clavicles are some of the yuckiest bones in the body and laugh every time you call her that, Robert. Well, that's her phrase. It's her catchphrase. It's not mine. You know, she made it up. Yeah, they're kind of strange, right? And they break very easily. And I don't know. Sometimes you can have some nice looking clavicles. I've seen some nice looking clavicles before. Ooh, look at those clavicles. But not on Clavicle Girl, that's for sure. Kelly says, why am I not seeing anyone bring up that insurrectionists stop the senator-backed objections so they actually hurt Trump's cause? Yeah, I think that's an interesting point, right? I mean, they were actually going to stop and pause. Like Ted Cruz was calling for a joint, right? Ted Cruz was calling for it. And it kind of wrecked everything. Like, I would have liked to have seen it actually come to its conclusion. But I think that's kind of the point, is they didn't want it to be investigated. Like, if they would have not allowed the insurrectionists to stop it, then maybe we would have had a 2-week pause. We would have counted the votes. Maybe Trump would have won. Who knows? B-Man says, how many of the people who instigated the violence at the Capitol are going to be in the jury? You saw the J6 tapes. Probably none of them, unfortunately. So it will not be a jury of their peers. That's for sure. Knox is here, says, LOL. So is Rachel Maddow hoarding food and stocking up on ammo? I don't know. Is she turning into a prepper? Like fascist Rachel Maddow? We'll see her on YouTube with a homesteading channel, preparing for life under Trump. Okay. Jane Catherine B says, if Trump had caused the beast to crash, would it have been attempted clavicular homicide? Well done, Janine. Jane Catherine B. Would it have been attempted clavicular homicide? That sounds like a pretty serious condition. They might have a cream for that. We got NY says, so have we given up on evidence of insurrection? Now we are now going to consider his intent to commit insurrection. Well, my answer to that is no. The 14th Amendment says commit, not attempted. We can only speculate as to how history would unfold. Says, thanks for covering this Goldman statement. He didn't say impeached. If Trump is harmed or attempted harm, Goldman should be charged with attempted elimination. He needs a Secret Service visit. Dim Sum said, when did Trump say he'll delete the Constitution? I have no idea. In Claire McCaskill's deluded reality. Audie, thank you, Dim. Audie Joe is here. 5 membos from Audie. Another person is here. D. Gillis. We got Jason, Bob J, and T.E. Terry E. also got membos courtesy of Audie Joe. Audie, thanks for being a membo, and thanks for bringing in more membos. We got a lot of membos coming in, and I'm grateful about that. We got Knox Bierman says, as a blonde, I'm happy to see all the villains are brunettes. Ooh, and it's about to get spicy in here. Blondes versus brunettes. I'm down for it. I'm down. Heather says, welcome, Heather. Welcome to a membo, a new shout out membo. Heather in the house. Nice to see you. Thanks for joining us. And look at this happy puppy in the photo. Catania Mama Italia says, happy birthday to me tomorrow. Gobble, gobble. Thankful for all of you watchers. Please don't drink and drive. Be vigilant. The government won't save you. Catania Mama Italia, happy birthday to you on a Thanksgiving day, nonetheless. You're going to have a nice meal, hopefully a big cake, and it's going to be delicious. And so thanks for stopping by. We're all wishing you a very happy birthday. And what a nice day to have a birthday on Thanksgiving. Everybody's getting together and having a nice meal and celebrating you. So thanks for being here. Happy birthday to you, Catania Mama Italia. We got this one from John Allen over on the Locals. Says, hey, Rob and fellow Watching the Watchers followers. I know that I've been quiet the past couple of weeks, mostly working and lurking. It's busy. It's a busy time of year. But I wanted to let you know that your streams have been awesome. Thank you, John. Says, thank you for all that you do and for helping us all keep our sanity. Wishing you and your family a happy Thanksgiving. Hi, Mama G and Joey. And we're going to be seeing them this weekend. Going to a Thanksgiving trip up north, leaving tomorrow. John says, and a happy Thanksgiving to all the Watching the Watchers group. And I think that's a turkey in there. And John, what a nice message, John. Thank you for sending that. That's John Allen over on the Locals. We're very grateful for John. Thanks for being here, my friend. And happy Thanksgiving to you. And thanks for helping keep me sane, too. We're in it together. NY says, Lois Lerner testified in front of Congress and was a political appointee, but not Senate confirmed. It's an empty argument. Yeah, it's just a fake because. They're just making something up. Sam in Texas says, when will these Democrats get scared and start flipping on Biden and the federal corruption in the DOJ and the FBI? Need leaders, not agents. She's one. It's a great question, Sam. And I've been wondering that myself. Like, what if it becomes a foregone conclusion that Trump's going to win? Like around election time, like it looks like just it's too late for them to swap Biden out. He's already been appointed. He's down by 10 points. Do people start, abandoning ship? They're like, oh yeah, hey, forgot to mention this, right? And they all start. It's the bandwagon effect, in other words. When does the bandwagon effect start? If Trump starts to pull away. We'll see if that happens. Lure Lab is here. Welcome, Lure Lab. Very nice to have you as a new supporter. Thanks for joining us on the YouTubes. And don't forget to grab the Telegram link over in the community tab section. Jack Mack is in the house. What's up, Jack? So generous, bringing in 5 new members. Daryl B, Fizbin G, James M, and Vinyota, along with Dorothy D, all coming in. New members. Thank you to Jack Mack in the house. Jack, you're the best. Thanks. We got this one. Hey, from Geegum Geegum. Oh my goodness. We got some seriously serious, nicely generous donos from our friends on Locals. This is from Geegum Geegum, our meme smith extraordinaire. Says, thank you for shining that spotlight as bright as you do. Happy Thanksgiving to you, yours, and the whole Watching the Watchers family. And this is what Geegum put together, and this is a fun one. So these are a bunch of membos over on the Locals, and you can see Geegum assembled this for all of us. Everybody's profile photos. It says, get your farm in the fight. Use conservative methods for better yields. I love it. Oh, it's so fun. Of course, you know who you are on the screen, but there are some very familiar faces out there. And Geegum put that together. It's a lot of fun. It's like, what were those things, the Thanksgiving? It's like a cornucopia. Remember those cornucopias? It kind of reminds me of that. But get your farm in the fight, my friends. And we're so grateful for all of you and everybody here. And so that was from Geegum. Thank you, Geegum, for sending that one in. And hey, Tanya Karras is here, also joining in. Tanya saying, man, super generous. You guys are awesome. Says, may I add to that? Happy Turkey Day to all. Indeed. Very, very generous. Thank you for that one. To Tanya Karras. And it's Turkey Thursday, I guess. We normally celebrate Taco Tuesday. And Tanya's a big Taco Tuesday supporter on our Locals. And it's going to be Turkey Thursday. Although we had a debate about tacos and turkey tacos and, what constitutes a taco versus a sandwich is an age-old debate. But hey, what's up? Thank you, guys. And this one from Angie Warren says, hello, Robert. Best on the YouTubes. Well, I don't know about that. But been a member for 6 months, Angie. Thank you for saying that. Thanks for the nice compliment. And thanks for being around for 6 months. It's a pretty long time. I guess you could say things are getting pretty serious. We got Zutral says, great show, Rob. I've been working and missing some live shows. I've noticed that, Zutral. I hope it's worth it. Hope you're getting some, productivity done. But staying tuned overall. Glad to make a live show today. Hey, everyone on YouTube, be sure to at least open the tab and follow and watch Rob on Rumble. I think that's great advice. And by the way, I've been having some very interesting email exchanges with Rumble, actually. Very interesting email exchanges. So I'll keep you posted on that. And please do consider locals as well. I said it there. I'm happy. Thanks. Zutral, you're the man. And thanks for the plug. I often forget to do that, but you know, I do appreciate that. I do appreciate you following us on all of the platforms because you never know what happens on the tubes. And so Zutral, thanks for sending that in. Very grateful for the plug. A Bad Poet is here, says it's so bad that Caitlyn needs a fact checker. Well, then what would she talk about on her show? There'd be like no show because it's mostly incorrect facts. All right, and that's A Bad Poet in the house. Thank you for sending those in, my friends. It is a beautiful, beautiful Wednesday. Before we wrap it up, let's say hello to our friends on the X platform. You can, of course, give us a follow over there on X at Rob Govea. ESQ is the address. Is anybody watching over here today? It is the day before Thanksgiving. It's a little bit light, and it's showing up in the numbers, isn't it? We got 5 viewers here. That's all right. That's all right. I'm sure they're going to watch it later. I don't have any doubt about that. But let's see who is joining us. We have a couple from George, Danny McWilliams. He says, turkey time tomorrow. Please, no one deep fry. But aren't those really delicious? I think they're dangerous as heck, but like, aren't they really good? Fred says, after much consideration, I've come to the conclusions that some judges are terrible. George says, Rob, I'm privileged enough to be able to catch most of your shows live. My family thanks you for taking tomorrow off. Well, we're still debating on that one. George says, how would it be possible to hold the fake news media accountable with the First Amendment? Well, not much. I mean, you could sue them like Trump is suing them, sue them for actual damages when they harm you, but it's hard to sue the media. You know, they have First Amendment protection, so it'd have to be something that is defamatory and whatnot. But those, my friends, were some comments over on the X platform. We're grateful for our friends on the X platform. And now we're going to wrap it up and go on over to our watchingthewatchers.locals.com after party. Want to shout out our friends over on Rumble. Indoctrination's over there. What's up, Catwoman? We got Terry NMB is saying greetings from Myrtle Beach. Woo, in Myrtle. Myrtle Beach. Good to see you. Thanks for hopping on. Dance Master. We got Little Galaxies over there. We got Catwoman. A Job Done Well is over there. Looks like a nice chat in the house. Very nice to see everybody. Thank you for coming over. And we're talking about clavicles. All right. And so, my friends, we are going to wrap it up and head on over to watchingthewatchers.locals.com. One final reminder, sign up for our newsletter at robertgovea.com. That way you can get all the show notes, all the segments delivered to your inbox, all the PDFs are there. If you want to learn how to use this mind map software, I also put together a mind map tutorial. Once you sign up for the newsletter, you can watch the tutorial and learn how to use this stuff if you're interested in it. But that is going to be it for us. We are going to say thank you to our mods and our meme smiths who mod the fort down for us and keep things nice and orderly. Our friends Vientikis Prime, we got K Bean in the house, we got Just Cause, Playin' Hooky, our friend Ronnie Cole, Zulu, Beyond Geo, Zach Nichols, John Allen, who I got another dono from, Janik, Dog Digger, and Donut Mind Me. We've also got Sleepy Dog Lee, Geegum Geegum, memeing down the fort for us and putting together some nice graphics, and Nathan, N810 in the house. And John sent this one in. I'm sorry, Hunter's Crack Dealer sent this one in. He says, Rob, Hunter's Crack Dealer here. Since Hunter's gone silent after his attempt to subpoena Trump, he says crack sales have plummeted. Come on, everyone, it's the holidays. Let's all help support this almost unemployed crack dealer and party hard for Thanksgiving. And this is joke and satire, okay? Don't do drugs. Disclosure, we don't support the use of illegal substances here and don't condone the sale or, oh, thank you, John, he included it for me, or procurement of any of the aforementioned substances. Oh, it's a joke, all right, it's a joke, YouTube. Okay, take it easy to YouTube censors and everybody over there. Thank you, John, for the very nice dono and the funny joke on the lovely end of the day. And Norman says, happy Thanksgiving, Rob, you rock. And thank you, Norman, for saying that. And you rock too, my friends, my friend. I am grateful for you guys. Thank you so much for sending all of those in today. Extremely, extremely generous. Tomorrow is Thanksgiving, my friends, and so I do hope that you have yourselves a very beautiful Thanksgiving. We are planning a little bit of a hello in the morning, so stick around. Make sure you have those notification bells set to alert, because there may be a stream in the morning if there's something to talk about and the mood strikes. So thank you for subscribing, of course, and following along wherever it is. We'll be very likely here in the morning to talk about something, if there's something to talk about. And so I do hope to see you right back here, so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. If we don't hear from each other, make it a beautiful Thanksgiving, and we'll see you right back here on the next one. Bye-bye.